Good afternoon, everyone. I am truly delighted to welcome you to our first webinar as part of AYLA's Earth Laws Month. My name is Michelle Maloney. I'm the co-founder and national convener of the Australian Earth Laws Alliance, or AYLA, as we love to call it. Today, I'm joined by Chief Justice Brian Preston, Chief Judge of the New South Wales Land and Environment Court. And in a moment, I'll invite Justice Preston to give his talk to us, and we'll have a few questions at the end. Before we begin, though, I'd like to acknowledge country. I'd like to acknowledge that I live, work and play on the beautiful traditional lands of the Kabi Kabi and Jinnaburra peoples in what is now the northern parts of southeast Queensland. It's become quite a Zoom tradition for folks to acknowledge country in the chat. If you would like to write down a hello or where you're from, it's always nice to see where folks are from. And if you're not from Australia, we'd still love to know where you're from, even if you don't know whose traditional lands it is. So at the end of our talk today, I might give a small advertisement for some of the other events going on in Earth Laws Month. We have around 20 online events covering law, economics, science, the arts, Indigenous knowledge, and a whole lot more. I'll put the link for the main booking page in the chat, and we would love to see you across the coming few weeks. We have got some pretty amazing people. But speaking of amazing people, here's a wonderful human being who has been willing to come and talk to the Australian Earth Laws Alliance crew for many, many years. I'm not going to introduce him much more because I think most of you know Judge Preston and his work. Judge, how are you today?
Well, thank you.
That's great. Well, look, without further ado, I'd like to welcome you, Justice Preston, and we're looking forward to your presentation. Thank you.
Good. Well, thanks very much, Michelle. A pleasure to present to your Earth Laws Month. My topic is the right to a clean, healthy and sustainable environment and how to make it operational and effective. Ambitious in 45 minutes, but let's see how we go. So I'm going to divide my presentation into three parts. The first is to unpack what is the right to a healthy environment. The second is to look at the correlative duties to uphold and protect that right. And the third is to look at what systemic or systematic change that we need in order to make the right operational and effective. Now, the concept of the human right to a clean and healthy and sustainable environment, I think, sort of hit the world stage in 28 July 2022, when the United Nations General Assembly recognized that right. Now, that followed on from an earlier recognition by the UN Human Rights Council, which had recognized a right to a clean, healthy and sustainable environment, and called upon the General Assembly to consider a recognition of the right, which they did on the 28th of July. Now, that recognition had already been seen in many other countries around the world. And so recently, the tally is that there is constitutional protection of a right to a healthy environment, 110 countries, and it's been recognized in legislation or regional agreements or even court decisions in more than 150 countries. So it is becoming a wide spread right. But what do we mean when we talk about a right to a healthy environment? Well, I'm suggesting that it's better thought of as a bundle of rights, that it's not just one right, but really is a bundle of rights. And if I look in that bundle, what do I see? Well, I could group those rights in three categories. Firstly, there's a substantive component to the right. Secondly, a procedural component. And thirdly, what I refer to as an intertemporal component. So let me unpack those. So the first is the substantive component. And as the adjective substantive suggests, it's describing the substantive content of the right. And as I've been saying, really that right is a cluster of other rights. And we can see that to be the right to life, the right to an adequate standing of living, or the right to participate in the cultural life of the community. I'll explain more of these in a moment. But we can see that's the cluster that makes up the substantive content of the right to a healthy environment. Now, a lot of these have derived from the primary right of a right to life. And so in order to understand what is a right to a healthy environment, it helps to go and look at what the courts have been saying the right to life embraces. So the right to life has been seen to have at least 4 components. The first, the most basic, is the right to be alive. The second is a right to access and enjoy the necessities of life. The third is a right to enjoy a quality life. And the fourth is a right to a healthy, functioning and flourishing biosphere. So the first 3 we can see are primarily anthropocentric, but the fourth is not only anthropocentric, it is also ecocentric. So let's start with the first, the right to be alive. Well, of course, the right to life involves the right to live, that is to say, to be alive and not dead. It involves people not being deprived of their life without due process and according to law. The second is the right to access and enjoy the necessities of life. And these include the clean water to drink, clean air to breathe, healthy food to eat, adequate sanitation, amongst many. Now, courts around the world have held that this right to life includes these rights to access and enjoy these necessities of life, and an expression coming from Indian cases, free from environmental hazards. So the Indian Supreme Court, I mean, there's many decisions, but I picked 2 in the 90s. They're referring to Article 21 of the Indian Constitution, which is the basic right to life. And they say that it includes the right to enjoyment of pollution-free water and air for full enjoyment of life. In another case, they say that right to life in the Constitution encompasses within its ambit the protection and preservation of the environment, ecological balance, freedom from pollution of air and water, and sanitation, and goes on to say, without which a life cannot be enjoyed. So what we can see from these cases is that any action that would cause environmental pollution, that is pollution of the land, air or water, which are the sources of life, should be recognised as amounting to a violation of the right to life. So some other cases. The first I'm going to refer to is the one in Colombia. So by Future Generations, and there's the plaintiffs there, and the Colombian Supreme Court upheld these the claims of the youth plaintiffs that the deforestation in the Colombian Amazon, which caused climate change, were threatening their rights to life, clean air and water, and a healthy environment. So they recognised that the deforestation of the Amazon led to emissions of carbon dioxide, which produced the greenhouse gas effect, and that transformed and fragmented the ecosystems, which affected water sources and water supply for population centres and land degradation. So those environmental hazards breach the fundamental guarantees rights to water, air, a dignified life, health, amongst others, in connection with the environment. Close to home, the Waratah coal and youth verdict litigation. So this is the final decision, the number 6 decision. There, the Queensland Land Court rejected or recommended the rejection of approval of a large open cut coal mine, amongst other grounds, on the fact that the greenhouse gases emissions from the mine would contribute to climate change, which would in turn threaten a suite of human rights. So the court observed that climate change will limit the right to life and is already doing so, and approving the project would contribute to foreseeable preventable life-terminating harm. The court found that the climate-associated health impacts of the mine would disproportionately affect Indigenous people and communities who were already at a heightened risk of illness and death. So my third category under this right to life is the right to enjoy a quality life. So my first one, I talked about a right to be alive, that is not dead. That could be thought to be a bare animal existence. But the cases suggest that the right to life extends beyond those first two categories to include having access to and being able to enjoy those aspects of life that make for a quality life as a human being. And that's a life in which each person can flourish and function with dignity as a person in their private and family life and in their home, and as a citizen in society. So what we can see is a strong linkage between a healthy environment and the fulfillment of these types of rights. Now, this was recognised by the District Court in the Juliana litigation, and they referred to marriage and said, just as marriage is the foundation of the family, a stable climate system is quite literally the foundation of society, without which there would be neither civilization nor progress. Going to the Uganda litigation in the Netherlands, that was at 3 levels, but the Court of Appeal of the Supreme Court dealt with the rights claim, that is a breach of the various rights under the European Convention on Human Rights. So the Court of Appeal and Supreme Court held that dangerous climate change threatens the lives, well-being and environment of citizens in the Netherlands and worldwide, and climate change threatens the right to life, the right to privacy, private and family life, home and correspondence. So those 2 articles are the European Convention. And they held that those articles impose an obligation on the state of the Netherlands to take positive measures to contribute to reducing emissions in order to prevent breaching those rights. Now, this right to a quality life has a special salience for Indigenous peoples and their communities. Indigenous peoples have distinct cultural rights, particularly the rights concerning their identity and cultural heritage, their language and traditional cultural expressions, their kinship ties, and distinctive spiritual, material and economic relationships with the lands, territories, waters and seas with which they have a traditional connection. So these distinct cultural rights are dependent on the conservation and protection of that environment, that is, of the environment of those lands, territories, waters and seas. So actions that harm or damage that environment will risk limiting Indigenous peoples' distinct cultural rights. Now, that was also acknowledged in the Waratah Coal decision of the Land Court. They found that climate change impacts will have a profound impact on cultural rights, and for some peoples who will be displaced from the country, it risks the survival of their culture. So looking at the cultural rights of Aboriginal people and Torres Strait Islander people, they are concerned with the very survival of their culture. And looking particularly at the Torres Strait Islander peoples, they face an existential risk from sea level rise. The court noted that First Nation people in the North Australia are already experiencing the effects of climate change, and that impacts on their ability to enjoy, maintain, control, and develop culture. So more severe impacts, which would come from improving the mine, would mean greater interference with those cultural rights, and displacement has the potential to destroy culture. So those are my 3 anthropocentric components of a right to a healthy environment. I now want to come to an ecocentric component. So this is the right to a healthy, functioning and flourishing biosphere. Now, those rights to life that I've articulated depend upon there being a healthy, functioning and flourishing biosphere. Because, as David Boyd, the current Special Rapporteur, says, all human rights depend on a healthy biosphere and a safe climate. Without functioning ecosystems, which depend on healthy biodiversity, there will be no clean air to breathe, safe water to drink, or nutritious food to eat. So this adds the dimension of ecological sustainability to the content of the right to life. And we can see that in the terms of the UN General Assembly's resolution, because it embraced a healthy environment. So it's not only a clean environment, it's a healthy environment. Now, an environment, it needs to be not only healthy for humans, such as providing clean air and water, that is the necessities of life, but it's got to be healthy in itself. It's got to be a functioning and flourishing system. Now, we can see that being picked up in the Sustainable Development Goals. So the 2030 Agenda for Sustainable Development set the 17 Sustainable Development Goals. And I've set some of those out. But if you look at those, including Goals 3, 6, 13, 14 and 15, you can see that include the right to life and a healthy environment. But now at the core of these SDGs is the concept of sustainable development. Now we know what that is, going back to the Brundtland Commission report, and it defines sustainable development that as being developed that meets the needs of the present without compromising the ability of future generations to meet their own needs. So what do we mean when we talk about the needs of present and future generations? Well, those needs are threefold, and they refer to the three pillars of sustainable development. So there is economic and social development, but there is also environmental protection. Now, in order to achieve ecological sustainability, achieving ecological sustainability is critical to achieving both economic and social development and hence sustainable development. But you also need to achieve ecological sustainability to achieve the right to life and a quality environment and a quality of life. So we can see that from the Human Rights Council, where it was acknowledged that human rights are an intrinsic part of sustainable development. Now, unfortunately, we're not tracking well. Again, David Boyd, in his recent report, says that as we approach the halfway point between 2015 and 2030, any hope of meeting the Sustainable Development Goals is disappearing like a mirage. And one reason is that the goals are misinterpreted as merely being aspirations rather than obligations. And I'll come back to this when I talk about what is needed to be done. But another reason for why we are failing to achieve sustainable development is the difficulty in determining quite what ecological sustainability involves. And as I said, ecological sustainability lies at the heart of sustainable development. Now, ecological sustainability needs to be assessed at different scales. At the largest, we can think of the whole Earth system and the scale of continents and oceans. Or we can bring it down to the scale of nations or subnational polities. Or we can bring it down to bioregions within those polities. Now, this is where Rockstrom and Steffen's planetary boundaries model can assist. So just to recap on what this involves, they identify 9 factors that influence the stability of the Earth system. So they calculate the degree to which current human activity is impacting upon these 9 factors. And they establish thresholds which, if crossed, may lead to ecological instability and catastrophic change in the Earth system. Now, 2 of the factors, climate change and biodiversity loss, are considered to be core boundaries because they are affected by all of the other boundaries, and even just by themselves, if they are crossed, can bring about the destabilization of the Earth system. So those 9 factors I've set out there. As I said, the 2 biggies are biodiversity loss and climate change, but you can see many others there. The next 4 concern various types of pollution, as does the 5th one. And then there is uses, land use change, or the rate of consumption and depletion of fresh water. So they depict it in this form of a pie chart. I think you can see that there's a ring, which is the threshold of stability for each of the slices of the pie. You can see as they the particular impact gets worse and worse, the pie slice gets bigger and eventually crosses the threshold of stability. So you can see there that climate change, biodiversity loss, land conversion, for example, are all crossing the boundaries of stability. So Roxburgh and Steffen identify that the current human activity has crossed 6 planetary boundaries, so the 2 core boundaries of climate change and biodiversity loss, as well as land use change, air pollution, chemical pollution, and fertilizer use. And we could represent or classify those as representing the 3 planetary crises of climate change, biodiversity loss, and pollution. So the consequence is the Earth system is already in an unstable state, and therefore we need multiple, multifaceted and multidisciplinary action to arrest and reverse this current instability in the Earth system. So let's move now from the substantive component to the procedural component. Now, under Principle 10 of the Rio Declaration and various conventions, such as the Aarhus Convention, there are 3 procedural rights. One is access to information on the environment. The second is participation in environmental decision making. And the third is access to courts to uphold and enforce these procedural and other rights. So the procedural rights are necessary to enliven and enforce the right to a healthy environment. There's no point having a right if you can't enforce it. So the procedural components of rights have been recognised by the courts. Let's start with the first, the access to environmental information. So John Knox, in his final report as Special Rapporteur, came up with a number of framework principles. And the 7th framework principle is that states should provide public access to environmental information. Now that right has been recognised by the courts, as I've just said. And MC Mater, the famous environmental lawyer, public interest advocate, has taken many actions to uphold the right to life under Article 21 of the Indian Constitution. And in this particular case, which I've selected, the Supreme Court held that the right to life, in order to be operational and effective, needs to be publicised. So the court ordered the publicisation of the right to life, including the constituent right to a healthy environment, in education curricula in primary and secondary schools, in tertiary institutions such as universities. And what I particularly like is even showing it in cinemas as an opening documentary before some Bollywood blockbuster. And I think that's a great idea. Now, my second element under Rio 10 principle is public participation. Again, John Knox incorporates this in Framework Principle 9, and that is states should provide for and facilitate public participation in decision-making related to the environment and take the views of the public into account in the decision-making process. Now, this component of the procedural component of the right was upheld in a South African case, so Sustaining the Wild Coast, and Minister for Mineral Resources. So a number of NGOs, but also traditional communities and local fisher people brought proceedings challenging a government grant of a right to explore for oil and gas off the coast of South Africa. The High Court of South Africa found that the consultation process that was undertaken with the traditional communities infringed their right to procedurally fair administrative action under the Constitution. And for 2 reasons. One, the seismic surveys, or the carrying out of these, was publicised in newspapers, but they were publicised in newspapers that circulated outside of the local area of some of the traditional communities, and they were published in a language that was not understood by those communities. And secondly, the communities weren't given proper notice of the nature and purpose of the proposed seismic surveys and sufficient information in order for the people to make meaningful representations. And the court held that meaningful consultations consist not in the mere ticking of a checklist, but engaging in genuine, bona fide, substantive two-way process aimed at achieving, as far as possible, consensus. Another case in Australia was north of the Tiwi Islands, so up in the Northern Territory. So NOPSEMA had approved a drilling environment plan that had been submitted by Santos for the sinking of gas wells in the traditional seas of the people of the Tiwi Islands. And so an elder of the clan, whose traditional country it was, brought judicial review proceedings challenging the approval, contending that the regulations required NOPSEMA to consult with the traditional owners and prior to approving the plan. And the federal court upheld that claim on those grounds and set aside the approval. Santos appealed to the full court, but that appeal was dismissed. And so the full court held that the elder who brought the action was a person whose interests were likely to be affected, so he was a person who needed to be consulted. And importantly, like the South African case, the consultation process must be adapted to the interests of the persons who are to be consulted. So in this circumstance, proper consultation with the communities required the drilling title holders to provide sufficient information to allow the affected communities to make an informed assessment of the possible consequences of the proposed activity on their interests. The third of the procedural rights is having access to the courts. John Knox formulated this as his principle 10. States should provide for access to effective remedies for violations of human rights and domestic laws relating to the environment. So a right to a healthy environment must be able to be enforced by the courts. Now this includes people not only having standing to sue, but also being able to participate in the very conduct of the proceedings they have brought in meaningful and effective ways. So a denial of access to the courts to enforce the right to life or the right to a healthy environment is, of course, a denial of the right itself. Now, for Indigenous people, being able to participate meaningfully may include being able to give their evidence on the lands, territories, waters and seas with which they have cultural connection. Now that was recognised in the Waratah coal case, but an earlier decision, the number 5 decision. So the Queensland Land Court found that to confine the evidence of the Aboriginal and Torres Strait Islander witnesses to their written statements, rather than to allow them to speak on country, would unjustifiably limit their cultural rights. And I referred to Section 28 of the Human Rights Act in Queensland, and the court held that it would be assisted in undertaking its evaluatory function by seeing and hearing this evidence being given in that community, and noted that written evidence from a First Nations witness is a poor substitute for oral evidence given on country and in the company of those with cultural authority. I said also about this access to the courts. It's access to the courts to enforce the environmental laws, and that means often governments ensuring the effective enforcement of environmental laws and decisions of the courts. So John Knox's framework principle 10 says that states should ensure the effective enforcement of their environmental standards against public and private actors. So government authorities need to effectively enforce compliance with environmental laws and standards by preventing and redressing violations of those standards by not only private, but also the government itself. So an example is OKAYA in Turkey, as this is under the European Convention on Human Rights, and it was decided by the European Court of Human Rights. So there, the plaintiffs had sought orders to stop the operation of 3 government-run thermal power plants that use low-quality lignite coal, and that caused significant air pollution and health effects. And the allegation was that infringed their right to a healthy and balanced environment under the Article 56 of the Turkish Constitution. Now, the Turkish courts upheld the plaintiff's claim and ordered the power plants to stop operating, but I said they were government run. So the Turkish government authorities refused to enforce the court's decision, and so they continued operating. And the police and other government agencies didn't take any action to stop them operating. So the plaintiffs applied to the European Court of Human Rights and said that the non-enforcement of the court's orders had violated Article 6 of the European Convention on Human Rights, and that is a right to a fair trial, because it's no good having a fair trial and getting an order if the court's orders are never enforced. And so they were awarded compensation. My third component of the rights is what I term as an intertemporal component. Now, the right to a healthy environment, of course, needs to be enjoyed by people who are alive, but that includes not only the present, but also the next generation. So all of those people should be able to enjoy the right to a healthy environment, not only today, but tomorrow and into the future. Now, the next generation, which is today's children, are sometimes impeded by the law and the legal system from being able to enforce their right to a healthy environment. But we do see some instances where children have been able to sue to uphold their right. I could have put here a slide dealing with the Tony Opposer's case, so Opposer and Factor in the Philippines, but I'm going now to the Torres Strait Islanders petition to the UN Human Rights Committee. So 8 Torres Strait Islander people, 6 of their children, made a complaint to the UN Human Rights Committee saying that Australia had violated and was continuing to violate their rights, and they'll set out those rights, by taking inadequate action to mitigate and adapt to climate change. That was upheld by the UN Human Rights Committee, and it found that Australia had violated their rights to culture and their rights to be free from arbitrary interference with privacy, family, and home. Now, the majority found that as of today, there hadn't been an infringement of the right to life, but the minority found there was. Nevertheless, whilst the majority said there was no current violation of the right to life, it did recognise that without robust national and international efforts, the effects of climate change may expose individuals to such a violation. Going to Germany, there's an interesting case where, again, youth claimants had challenged the constitutionality of Germany's Climate Protection Act. Now, that act set, it was alleged and was found, inadequate greenhouse gas emission reduction targets. The problem was that the targets provided for insufficient reduction in the short and mid-term, but provided for much greater reductions in the long term. Therefore, the burden of reducing greenhouse gas emissions was imposed on future generations, not on the present generation. And so the Constitutional Court found that the German Constitution enshrined a right to future freedoms. And that right protected the claimants, the youth claimants, against threats to freedoms caused by greenhouse gas emission reduction burdens being offloaded onto them, the future generation. And the failure of the Act to set emission targets beyond 2030 limited these intertemporal guarantees of freedom. So the court ordered the federal government to remake the Act effectively and to set targets which were more ambitious and to stop this intertemporal effect on burden on the future generations. Now that's a long presentation about the right, so I tried to unpack the components of the right. But we can also get an understanding of what the right involves by looking at the correlative duty to protect that right. Now, Wesley Hofield distinguished different types of rights. He said the term rights is used imprecisely. And so he distinguished rights to do things which he termed privileges, for rights to have things done for or to a person, which he termed claim rights. So he said that claim rights have correlative duties, but privileges don't have correlative duties. Instead, a privilege has as its correlative the absence of a right that the actor not do that which the actor has a privilege to do. So when we look at the right to a healthy environment in the way that I've unpacked, we can see that it involves both a privilege as well as a claim right. There is a privilege because the holder of the right may seek to use and enjoy the environment. But there's a claim right because the holder may claim that the environment be protected. Now, as I said, under Hofeld's classification, only the claim right gives right to a correlative duty to respect and protect that right. So let's have a look at what that correlative duty might involve. Now, we can see that the correlative duty is to respect, protect, and uphold the right to a healthy environment. That's the cluster of rights. And that duty is imposed on government. So courts have held that government's duties are to protect and uphold the right to a healthy environment and similar rights to life and to live in a healthy environment. So I won't go through in this lecture all of the different duties. I'm going to pick out three categories of duties. The first concerns the public trust. Now, and the public trust is over those resources that may be classified as the commons. These are communal natural resources. Now, those communal natural resources are incapable of individual appropriation. One can't have property in the air, the atmosphere, or in running water as running water. And so there's a public trust over those communal natural resources. The government is the trustee of that public trust, so it owes fiduciary duties. And the people, as the beneficiaries of the public trust, have the right to hold the government as the trustee accountable for its management of the public trust. My second category of duties that we can see is duties to protect the forests. And we've seen a number of cases, particularly in South America, where the courts have upheld the government's duty to protect the forest and particularly public lands against environmental harm. So in an Argentine case, the Argentinian Supreme Court held that the clearing of 1 million hectares of forest posed a risk of serious damage, which threatened violation of the right to a healthy and balanced environment. Back to that future generations case, the Colombian Supreme Court held that the deforestation of the Colombian Amazon posed an imminent and serious threat to current and future generations due to its impact on climate change, and that this in turn attacks the fundamental rights to life, water, clean air and a healthy environment. Interesting there, the court also found that the Amazon is an entity that is subject of rights, and that the Colombian government had a correlative duty of protection, conservation, maintenance and restoration of the Amazon. So the court made orders against all three levels of government, so the federal, municipal and regional government, to propose plans which would reduce deforestation and enforce compliance with their duties. My third category is the duties to take climate action. So courts have been holding that governments do have duties to take climate change action. Not only mitigation action, such as was held in the agenda case, but also adaptation action, such as held in the Legari case, to prevent harm to people and planet. So let me turn to that Legari case. There, the Pakistan government had adopted policies for adaptation to climate change. But the problem was, as often happens, they failed to implement those policies. Now, the Lahore High Court held that the government's failure to implement their policies meant that there was inadequate adaptive action taken. And that led to a breach of fundamental rights. including the right to life, the right to a clean and healthy environment, and the right to human dignity. So by way of remedy, the court established an ad hoc climate change commission to formulate and implement the action that was needed to implement the government's policies for adaptation to climate change, and then ordered that that action be taken. So that's my quick run through the duty side. But what we can see there is that that right to a healthy environment, in the way that I've unpacked it, can only be operational and effective if there is a duty to protect and uphold that right, but also that that duty is discharged. Now, this requires proactive, systematic change of both law and governance. Now, some of the cases I've referred to are examples of where the courts have held the governments accountable for their inadequate actions and inactions, which have infringed people's rights. But what we see that is an example of reaction. It's not proaction. It's an example of governments being ordered to discharge their duties to protect human rights in the individual case, but it doesn't go further. So what we need is for governments to be proactive, not just reactive. They need to be proactive in effecting systemic and structural change. So change in both the laws and policies, in the constitutions and the governance systems, so as to protect and uphold people's rights. By securing a clean, healthy and sustainable environment, that state of affairs, both the right to that environment as well as the duty to protect that right will be achieved. Litigation is too difficult, costly and few and far between in order to achieve this goal. So governments must act independently of reacting to litigation and instead proactively effect systemic and structural change in the laws, policies and governance of the environment. Now, we're seeing international calls for this proactive change. Now, I've referred to the UN General Assembly adopting in July last year the right to a clean and healthy and sustainable environment. In doing so, it called upon states, international organisations, business enterprises and other relevant stakeholders to adopt policies to enhance international cooperation, strengthen capacity building and share good practices in order to scale up efforts to secure a clean, healthy and sustainable environment for all. So what we see here is that the key is to actually achieve a clean, healthy and sustainable environment. If we do that, the right to that environment and duties will all fall into place. But in order for this to occur, we need whole of government as well as whole of governance review and reform. Now this requires we identify the drivers and the causes of ecological instability and then come up with the solutions. So where can we look for guidance as to what are the causes and what are the solutions? Well, I can suggest two things that I've already referred to. The SDGs, the Sustainable Development Goals, and the Planetary Boundaries Model. So starting with the Sustainable Development Goals, then that agenda actually directs attention to what needs to be done because it sets the targets, it sets the actions that are prescribed for each goal. And so that it directs attention to how to achieve the goal and when we can say that that goal has actually been achieved. So the SDGs provide a blueprint for achieving peace and prosperity for people and the planet. But as I've earlier pointed out, and David Boyd noted, but if we are to achieve that, we must look at the SDGs not as mere aspirations, but rather as obligations which must be implemented. And to do that, we need to embed those obligations in the laws and policies of the state, and they need to be made legally enforceable. Whatsoever there is a discretion to implement the SDGs, to take the actions that prescribe for each goal, then we will continue to fall short. I also referred to the planetary boundaries model, and Rockstrom and Stefan addressed the ecological side, what was needed to achieve the ecological sustainability. Kate Raworth takes that planetary boundaries model and injects the other two pillars of sustainable development, social development and economic development. So it incorporates the social and economic needs of the people as a social foundation that needs to be achieved. The Kate Raworth's model is often called the donut model because it, you can see there that in the centre, the whole is how she works out whether there is a meeting of the three pillars of sustainable development. So not only ecological protection, that's the ecological ceiling, but also economic and social development, which is the social foundation. So we can see the ecological ceiling, which is set by the planetary boundaries model, is the outer edge of the donut. The social foundation is the inner edge of the donut. So the basic needs of the people are the whole of the donut, shown as slices, again, in a pie chart. So the radius of the whole of the donut sets the point at which each basic need can be said to be met. Right? So the goal is for each basic need to reach across not only, if I go back here, the ecological ceiling, but also through the social foundation. So the current extent to which the basic need is being met is shown by the length of the slice for that basic need. If the length of the slice is less than the radius, there is a shortfall in the provision of the basic need. So what we can see is that Raworth's donut model provides a blueprint for achieving all three pillars of sustainable development. The outer ring is an ecological ceiling below which we must remain to maintain a stable planet. That's why it's a ceiling. The inner ring is the social foundation above which we must aim to raise everyone to achieve people's economic and social needs. Now, I've said that there needs to be all of government reform. So all branches of government need to effect systemic and structural changes in law, policies and governance if we are to achieve or ensure the right of all people to a healthy environment. So the legislature needs to pass laws and the executive needs to make policies in order to achieve sustainable development. The legislature and executive need to identify what institutions and governance systems are needed in order to achieve sustainable development. But there is also a role for the judiciary. The judiciary needs to hold the legislature and the executive accountable for any unlawful discharge of their responsibilities and to encourage systemic and structural change by the judiciary's choice of orders to remedy any proven breach of law. I'll give one example. It's a case I decided. And here, the court issued an order in the nature of mandamus directing the Environment Protection Authority to perform its statutory duty under the Protection Environment Operations Act to develop, Protection Environment Administration Act, to develop policies to protect the environment from climate change. So this order not only remedied the EPA's failure to perform its statutory duty, but it did more. It effected systemic and structural change in governance in relation to climate change, because the policy set the parameters for government action. Now, the EPA adhered to that decision and prepared and released in January a climate change policy and climate change action plan. So that brings me to the conclusion. The increasing recognition of the right to a healthy environment, as I've shown at international and national and subnational levels, is an important and much needed step in making peace with nature. But the right to a healthy environment needs to be made operational and effective. It's not enough to have a right on the books. it needs to be a right that's implemented in practice. Now, in order to make it operational effective, we need to delve deeper into what the right to a healthy environment involves. And I've tried to give you some idea about that by looking at the substantive, procedural, and intertemporal components. We also need to recognise and explicate the correlative duties to respect, protect, and uphold that right. And finally, we need to be proactive in effective systemic and structural change in the laws and policies, institutions, and governance systems in order to achieve sustainable development and ecological sustainability. And thereby, by doing those things, we will protect that right to a healthy environment and discharge the duties to protect that right. So thank you. Concludes what I want to say.
Thank you very much, Judge. We have heaps of questions. Judge, are you happy to stay on until 1:10 instead of finishing at 1? Or do you have to go in 5 minutes?
No,
okay.
That's fine.
In which case, with everyone's permission, I have grouped several of the questions together. There are some similar issues. And normally I go in order of when the questions are received, but with permission from everyone, I'd like to go straight to a generic couple of questions around climate change and different governments permitting new coal mines. So Judge Preston, there are a number of folks, about 7 or 8 folks have actually asked, with regards to rights to a clean environment, how can we enforce our human right to some kind of emission-free environment and enforce the government's duty to protect those rights when we're seeing clearly blatant breach of both? And that's a simple summary of there are other questions going. How can we expect governments to act proactively and decisively on climate change when it infringes on profits and otherwise vested interests? And a really terrific question, I think that one's from Paul, saying, regarding proactive and reactive approaches with respect to proposed new coal mines in Queensland and Australia, at what point would the replication of, for example, the Waratah precedent lead to laws and policies being amended to stop new coal mines? Or can we expect governments to simply leave it to reactive litigation indefinitely? So I think there's a genuine interest in folks, how do we use these rights and laws to support the reduction of those things that cause climate change?
Well, big question.
It's a big question.
From the court's perspective, courts are reactive institutions, so we can only react to the litigation that is brought. Now, the litigation that can be brought is dependent on the laws of the land. And so if the laws don't, for example, preclude the approval of new coal mines, then the executive government can, in its discretion, decide to approve them. Now, how do the litigation try to constrain that? Well, in the absence of a direct prohibition on the approval of new coal mines, they have to try and find that the approval of the new coal mine will breach some other law. And so one way they do that is through human rights. And so the litigation in Europe depends upon the European Convention on Human Rights. And so we've seen in the agenda litigation the invoking Articles 2 and 8 of the European Convention to say that the government's failure to reduce with sufficient ambition the greenhouse gas emissions in the Netherlands infringe those particular rights. So there's no easy answer in Australia, as I said, absent a particular law which says there shall be no new coal mines, or then they have to find how an approval would breach some other law. Now, we saw that in the Sharma case. So the Sharma litigation said, well, the approval by the Federal Minister for the Environment of a coal mine under the EPBC Act would infringe a common law duty of care. That was upheld at first instance, was overturned on the full federal court because they said under the EPBC Act, there wasn't. It wasn't to be interpreted as having attached to the statutory discretionary power a common law duty of care. Now with the Pabai and Cabai case, which is they're trying also to run a duty of care argument, and we'll see what happens with that. So that sort of creativity is what is needed in the absence of a particular express law. At the end of my presentation, I went back to say that we need whole of government and governance change. And I identified that the the legislature and the executive need to make effective climate laws and policies. If they don't do that, we're not going to tackle the climate crisis. So they need to do that, and that's people are asking what we can do about it. Well, lobby both Parliament and the executive government to make those laws and to make those policies. That's how we're going to affect the change. The judiciary can nibble away at the edges, but it can't go to solve the whole problem.
Mm. Thank you, Judge. There were also a couple of questions still within the Australian jurisdictions about air pollution and forests. So I'm framing those questions so that you can respond perhaps to all of them. Dorothy's asked, can the right to a healthy environment be used, for example, in New South Wales to try to stop wood heater pollution? And a similar question from Arabella from Victoria. How do we compel the Victorian government to act with urgency on public health issues around air pollution? And although it's different, it's still trying to find ways in state law, I guess, to make change. Jenny's asked, are citizens in New South Wales able to take legal action to end native forest logging?
Well, the one about sort of air pollution, is similar to what I've said before. If we don't have entrenched a right to a healthy environment, then one has to look at other avenues. There's a couple of ways in that could be done. One might be invoking the principle of legality, and another is how one interprets laws to make them consonant with upholding human rights. Now, if you want more detail on that, there's a couple of articles that I have written on that. One has been published by the Journal of Environmental Law, co-authored with Professor Kerry Warnock. So have a look at that. And that looks at the principle of legality in Australia, the UK and New Zealand, and whether it could be invoked for climate change. The second article has just been published by Monash University Law Review, co-authored with Nicholas Stewart, and it also looks at the principle of legality in climate change litigation. So that's just an avenue. But going back to what I said before, we've got to get laws changed. Not only do we have to sort of change the substantive laws, but we also need laws that expressly recognise a right to a healthy environment. And so we have human rights in legislation in Victoria, ACT and Queensland, although none of them at the moment expressly recognise a right to a healthy environment, although I've heard the ACT is thinking about amending it to include that. But there is currently an inquiry into whether there should be a Commonwealth, a federal human rights bill legislation, and probably a number of you made submissions, but that also could be looking at whether there should be a right to a healthy environment included. So you could follow that through.
Thank you, Judge. And I remember when Queensland was putting together its human rights law, a right to a healthy environment in strict form was actually rejected. It was seen as going too far. But people are still working on that and trying to get that into the Queensland space. I found a link. Oh, sorry, so is Jane. There's a link now put in the chat, folks, about that federal inquiry into a human rights framework. So, Judge, in a nutshell, litigation can only go so far. It can creatively try to grab the hooks that are available in the legal system and go forth to seek further judgment, as the Sharma case did. But with many of the issues that people are asking about, without an actual law in place stopping coal mines or saying that logging old forests is illegal, there's got to be lots of different ways to make those changes. That's unfortunately the situation many of us face, isn't it?
Hey, look, litigation can have a consciousness raising effect. So even unsuccessful litigation can nevertheless make people think about issues and raise awareness. So Sharma was ultimately unsuccessful, but I think it put the issue of that there ought to be a duty of care on the federal minister to consider what will be the impact. And I think the subsequent government, with the current minister, Tony Plibersek, although she's approved some coal mines, she has also rejected others. And one could speculate, but undoubtedly the litigation, the Sharma litigation, may have brought the issue to the surface. And so the government is more conscious of what will be the consequences of approving new fossil fuel developments. So I'm not saying it has a decisive effect, but I think it has changed people's awareness and the government's awareness.
Thank you, Judge. Turning to I've grouped some of the questions which have asked about the possibilities of bringing some of the international earth-centered law trends into Australia. So I'm going to paraphrase the question. We've had someone ask, Mark's asked about what's the prospects of enshrining the concept of ecocide in national law? How would that fit into an Australian framework? Also, someone has said, could a plaintiff bring a rights of nature case in Australia, even though there are no rights of nature laws, arguing that it's become a customary law and that it should be considered in Australian law? I might leave those two questions. How can, could it be possible for people to bring cases that would actually be heard at some point on issues that are not currently in Australian law, like ecocide or rights of nature?
So on the ecocide, I mean, the short answer is until ecocide is recognised both internationally and nationally as a crime, then one can't successfully sue on ecocide as such. That's not to say that causing that serious degree of environmental harm might not be a crime under other legislation, it's just not called ecocide. So you could find existing statutory provisions which sanction, make it as an offence, causing significant environmental harm by causing extinction of endangered species or chronic pollution or something like that, because they will be an offence under existing laws. But there is a push for ecocide to be recognised not only as an international crime, but also under national laws. And so a number of countries around the world, I think I'm just forgetting which one it was, but I saw just recently, is proposing to amend its criminal code to add ecocide as a crime. So there's nothing stopping Australia under the Federal Crimes Act or under the each of the states could do it, making ecocide a crime. Now there's a debate going on about how to define the crime, and so Philippe Sands's group has come up with one definition of what ecocide is. Others have come up with other definitions. It doesn't matter. The crime can be whatever the legislature says it is, but it involves a significant environmental harm. So that's that.
Yep. I was just going to say, Judge, thank you for raising that. At the end of this month, in Earth Laws Month, we're hearing from Jojo Mehta, who was co-partnering with the late Polly Higgins in their work looking at ecocide within international law, and their work trying to get a definition for ecocide. And I just wanted to give a plug. We've got 2 webinars on the AILA website from last year with a group of legal experts talking about how ecocide could be brought into Australian law. AILA hosts a working group looking at those issues. So there is some information about that in the Australian context for those who are interested. And I just wanted to add, someone's asked about legal personhood for rivers and other entities. Within the Australian Earth Laws Alliance, we've been looking since the beginning, 15 years ago, at this emergence of recognising the rights of nature in a jurisdiction, but also recognising the rights of nature for one particular ecosystem. And that could be by recognising the legal personhood of that place, but other ways are also being used to say that this river has rights or that forest has rights. It doesn't just have to be legal personhood. Judge, do you have any thoughts or comments on the prospects of having that kind of legal approach moving forward in Australia? We know the Yarra River was recognised as a living being, but it doesn't have its own legal rights. It's still seen first and foremost as the legal property of the Crown, but it is one of the first acts in Australia to ever recognise an ecosystem as a living being and recognise First Nations people's connection to that place. Do you and your work see any trends towards more people arguing for that?
Yes and no. The problem is, as far as in the courts, what I said before, people can only bring actions based upon the law that exists at the moment. And it's difficult to see where the hook is for rights of nature. But one can be creative about it. Well, before I move to that point, so we're talking about a right to a healthy environment, and I was supposed to say that should be implemented in legislation. But there's no reason why one can't say who the holder of that right is. At the moment, because it's seen as a human right, the holders are humans. But there's no reason why one can't say that the holder could be nature itself. So to take, the Yarra River or the Whanganui River, the river itself and its constituent ecology could be the holder of the right and bring it. So you can write that into legislation, but it would need to be done. Now, what's the workaround until that happens? Well, that is, one focuses on the duties rather than the rights, because there are innumerable duties in environmental legislation. So there is a duty not to take and kill threatened species. There is a duty not to pollute waters. Now, Hofeld talks about the correlatives. So what's the correlative to those duties? Well, one could see it's a right not to have the river polluted. It's a right not to take or kill threatened species. It then becomes simply a procedural point as to who can enforce that duty. And it could be any, under New South Wales laws, it could be any person can bring those proceedings to enforce that duty. But in doing that, it actually upholds the right, the correlative right. So that's the workaround. One can see that until we get an explicit recognition of rights of nature to various things, we can do the workaround of enforcing a duty with respect to nature. And by enforcing that duty with respect to nature, we, in effect, uphold the right of nature.
That's actually a wonderful segue. I do apologise, folks. A few questions we didn't have time for, but a really important final question that came through was about, we live in a colonial country. the British Empire brought its laws to this continent, but First Nations peoples would argue very strongly that their legal system is still in place. I read recently that I think it was an article by Donna Bagnall that in effect Australia has become a legally pluralistic nation since Mabo because it actually recognises native title. My question, Judge, and there's been 3 private questions that have come through in a similar way. What will it take for Australia's modern Western legal system to start recognising the actual worldview and laws of Indigenous peoples of the continent? Do you ever see that happening?
It can. I mean, what my last answer is, we can, without explicit recognition, we can see a sort of a workaround solution so that there are some recognition in the implementation and enforcement of Western laws. So how could that come? Well, I know from a very long time ago when I lived and worked in the Northern Territory, in sentencing for crime, these are crimes under Western law, they took into account Aboriginal customary law. And that influenced, and sometimes quite considerably, the judge's discretion in sentencing. So that way there is a infusing, a recognition of customary law. In one sense, in some of the decisions in the Land Environment Court about restorative justice, sentencing for offences against Aboriginal cultural heritage, there has been a recognition of Aboriginal, customary, heritage and law in coming up with what is the appropriate remedy and sanction. So I could add up. So there are ways in which it can be taken into account. One could take into account Aboriginal, well, Indigenous, to make it more general, Indigenous ecological knowledge in environmental decision making. And so, insofar as that traditional knowledge is, interrelated with, indeed infused in customary law, then that also is a taking into account of those factors. So we can take into account, customary law and traditional knowledge now, but it has to be done indirectly. But there's no reason, again, why we can't change our laws to expressly recognise that law and knowledge and say that it should be taken into account in decision making and governance. That has been recommended. Dr. Judith Preston wrote her Doctor of Philosophy thesis on precisely that, how to incorporate Indigenous ecological knowledge in environmental decision making, how to incorporate that into the laws at federal and state level.
Well, that sounds terrific. I'll definitely be reading that one. Judge, I would like to thank you very much for your time, and I'd like to thank everyone for your really thoughtful questions. However, just before everyone runs away, I must do my job, and I must do a very quick advertisement. That's the wrong page. For the rest of AYLA's Earth Laws Month. Given you folks, you lovely folks, have joined this discussion from Judge Preston about the Australian legal system and environmental law, may I urge some of you who have asked questions about the very machinations of our legal system to join a couple of our talks this Thursday. We've got Decolonising Our Thinking, Feelings and Actions, where myself and remarkable Indigenous thinkers and writers Mary Graham and Yin Paradise will be talking about what it is to be colonial, decolonial, and all of the things in between. We also have a wonderful talk by Mary Graham next week as part of Earth Economics Week, which is inside Earth Laws Month. But it's about the Indigenous relationist ethos and how it fits together with a different model of economics. And the other one I wanted to mention on law, is actually the ecocide one. But if you do have a little peek, we've got a beautiful mix of artists, lawyers, economists, scientists, and this year our very first doctor. Dr. Dimity Williams will be talking about how Western law is engaging with notions of a prescription for nature. But you may be interested in the Ecocide update on Thursday the 28th. Oh, and I should mention, I've been lucky enough to invite and be accepted by many, many folks around the world. We'll be talking pretty much all day on Thursday the 28th about rights of nature developments and legal personhood developments in their country and jurisdiction and what's going on. So I've popped the link in the chat. And I'm really grateful to all of you for being here today, but a very special thank you again, Judge Preston. Really appreciate your time, your wisdom, and your sharing. And we will invite you in to give us more updates, hopefully in the next few months or next year. So thank you.